right, this is case number 20144698. This is Oakland Community College versus Cameron Hill. The matter is before the court on the issuance of a subpoena. The record should reflect that a judgment was previously entered in this matter. That judgment is for the total sum of $2,359.16. It seems this is an effort, it seems, to collect on that judgment. That judgment was entered on the 6th of October 2020. Your appearance for Oakland Community College, please.
Judge, that attorney had another matter in another courtroom, so he said he would Zoom back in.
All right, thank you, Madam Reporter. We'll come back to that matter.
Okay.
The court now calls case number 22-188-353. This is Coleman Sachs Bank versus Erica Wilkes. The matter is before the court, wherein the matter is set on for a hearing on today's date. It does appear that I've received the defendant's answer regarding this matter. Your appearance for Coleman Sachs, it appears. Your appearance at this time.
Yes, good morning, Your Honor. Attorney Jason Brainer on behalf of Goldman Sachs Bank. My P number is 69653.
Good to you, counsel. I figured that might be Goldman instead of Coleman. It's got something strange on the readout here, but we got it straight. All right, for defendant regarding this matter, your appearance at this time.
Good morning, Your Honor. Edward Taylor, P57166, standing in for the attorney of record, Aaron Ogletree, for the defendant, Your Honor.
All right, thank you, counsel, and good morning to you as well, sir. It looks like this is the first time that this is up after the matters have become joined by contest. I don't have a complete file on this matter, so it looks like the claim relates to some approximately $5,500. Is that correct, counsel?
Yes.
All right, so I take it that there's been no discussions in regard to trying to see if there is some room to get this worked out as of yet, to the best of your knowledge, Mr. Brainer.
There actually have been some discussions, Your Honor. As of recent, I have seen where Attorney Ogletree, brother counsel, has tried to reach out, and we've had some back and forth. So, our hope is today is that perhaps if we could get a scheduling order with a period of discovery, my anticipation is, based on the contact we've had with brother counsel, that hopefully we'll work it out within that time frame.
All right, got you, counsel. Mr. Taylor, I know you're standing in, sir. Is that your information as best as you know regarding this matter?
Well, Your Honor, I've spoken with Ms. Wilkes, and she gave 35 payments for 429. So she's paid the balance off. This is all interest. And so she was going to offer $2,500 today if they would take that. Otherwise, Your Honor, she's going to have to file bankruptcy. She's considering that. So I was trying to put that on the table, Your Honor.
All right. Why don't we do this? And take a moment? Why don't I send the two of you to a breakout room, just see if there is room to discuss based upon what some of the things that have just been said. And you can come right back in. If you can't get some traction on this, I will set up some type of schedule for it. But at least drill down on what the offers may be in terms of trying to resolve this. So, Mr. Brainer, I'm going to send you a notification to breakout room number 1. And
Okay.
Mr. Taylor, I'm doing likewise with you. And you have priority. You come back in, I'll get right back to your file. I have it right in front. So let's see if we get some traction with this. All right, the court now calls case number 22-242-568. This is Jacqueline Miller versus Red Baron Enterprises LLC. The matter is before the court set on for a hearing today's date. Looks like there's a motion hearing and the court has set on for a pretrial. Your appearance regarding the matter for Jack McMiller. Do I have Ms. Miller here?
Before the court, there is a motion.
Yes, I'm here.
All right. Good morning to you, Ms. Miller. Are you represented by counsel this morning, ma'am?
No, I'm not.
All right. Thank you, ma'am. For defendant Red Baron Enterprises LLC.
Good morning, Your Honor. Sean Murphy here on behalf of Red Baron Enterprises, P79255.
All right. Thank you, counsel, and good morning to you as well as to Ms. Miller. All right. So it looks like there's a motion for entry of default on the counterclaim. Well, it looked like the court, like I said, well, yeah, I set it up for a hearing on a previous date. So counsel, go ahead and update me. I think on a previous date that I did enter some type of order disposing of the matter in some way. Talk to me, update me if you will.
Yeah, Your Honor, you did enter an order. You took the order or petition for entry of default under advisement and allowed her an opportunity to answer the complaint. She has since answered the complaint. So at this time, Your Honor, we'd be asking for a scheduling order to allow us to conduct some discovery and potentially move for a motion for summary disposition based on some of her admissions.
Got it. All right. So ma'am, you understand what's going on at this stage, Ms. Miller?
No, I don't.
All right, so it seems to me that the matter is probably joined before the court. There's not a petition for, oh, sorry, that could not enter a default against the defendants at this time, and no default will be entered against you. That the matter is set up now where the parties can litigate the matter in front of you. That's where this case is now. So what I'm going to do is I'm going to put it on a 60-day discovery path. That means that either party that may have any information that they wish to obtain from the opposing party may request such information during that 60-day period, and the other side is required to turn that information over. If interrogatories are sent, meaning sets of questions, and the party receiving interrogatories are required to answer those questions. If there's a request for production of documents, then the party receiving that request have to produce such documents. If there are requests to admit, which are requests that are in the nature of, do you admit that certain things occurred? The party receiving that is required to answer those items and get them back to the other side in a timely fashion. That process is called discovery. And Ms. Miller, if there's information that the defendant counter plaintiff has possession that might help your case, in that period, that 60-day period is the time that you want to put in writing your request for any information that may be under their control. They likewise have the right to request information that you may have that may be beneficial to their case that they would request from you. Also, I'm going to set it up where the parties can file petitions that they'd like for the court to hear on the next action date. Those petitions are commonly referred to as motions. A motion is a request for the court to do something. Either party can file a motion and set it for hearing in front of me on the date that I'm going to give you. The only requirement is that you must give the other party at least 10 days notice of what you're asking the court to do. You file your motion, give the other party 10 days notice, and the court will hear it on the next action date. That date that I'm going to give you, that's approximately 60 days from now. That's when you'll come back to court. That date is
14th.
December 14, 2022. And that's going to be at 9:45 a.m. December 22, strike that, December 14, 2022 at 9:45 a.m. Discovery, that is the exchange of information, is open through that date. Also, that date is a date that can be used for a motion hearing. So if you file a motion and set it for hearing on the 14th of December, I will hear it on that date. The only requirement is that you make sure that the other party has at least 14 days, strike that, at least 10 days notice of the petition, and I will hear it on that date. You will get a written order of, a written scheduling order from me in the mail in the next few days. That order will say the very things that I've already indicated to you. Paragraph number 6 will address the issue of the right to file a motion and set it for hearing. Notice that the following motions that I've set forth herein shortens the time that would normally be allowed under the court rules. But by court order, you can file your motion, dispositive or otherwise, and as long as the other party has at least 10 days to respond, I will hear it on the motion hearing date. Now, if you do not file a motion, then on the pretrial date, I will give opportunity if the parties believe that there is a motion that they should file, really have another crack at it. This is a way to accelerate the case, that if something comes up wherein you have a motion you'd like to have heard, you can use the opportunity of this next 60 days to set that up for an opportunity to be heard. All right. So both sides will receive a copy of that order in the next few days. The next hearing date is 12/14/22 at 9:45 a.m. I do wish you well, Ms. Miller.
Excuse me, I have a question. I've already filed a motion way back when, and I paid for it. Do I have to pay for another motion?
It seems to me that you filed a motion for entry of default. Is that what you
No,
filed now?
no, I didn't file that.
Yeah,
The defendant filed it for default.
I didn't ask you all that. What did you file? Don't slow down. What did you? That's what.
Oh, I'm sorry. I didn't hear you. I'm sorry.
Yeah, that's okay.
I filed a motion for them to produce because they said that I harmed their business and their income. I filed for them a motion for them to show that they have lost income. You know that. So I filed that. Ooh, it's been a minute.
Got it. Typically, that kind of motion is basically filing a motion for them to have a trial.
No,
listen to me.
Okay. Go ahead.
If they file a motion against you saying, prove that what you said is true, that's what the trial is for. However, if there are documents that you're requesting in this discovery period that I've set up, is the period in which you're entitled to request any documents. So I'll take your motion under advisement. I'll take another look at it. But if what your motion is saying is that you want documents that they are using to support their claim, then you're entitled to such documents. Counsel,
Right.
What she's indicated to the court is she's making a formal request that whatever the allegations are in the complaint, strike that a common claim, she would like documents, a copy of documents that the counter plaintiff intends to use to show the loss of business or opportunities that is alleged in the counter claim. You understand, counsel?
Yes, Your Honor, we have not received any motions or otherwise discovery from Ms. Miller.
All right. So the extent to which that is true, Ms. Miller, what you do is whatever you put in writing and send to the court, the discovery process is now, you got to be listening. The discovery process is now open. Take whatever document you filed as a motion and submit that document to Mr. Murphy's office. In that document, you want to make sure that you are specifically requesting items that you believe are under the control of the counterclaimant. It is proper for you to request documents. If they have alleged a claim, you can certainly request documents to support that claim. So your request should be in the nature of whatever it is that they intend to use to prove at trial that they have losses, that you'd like to have a copy of that. And you're entitled to that during the discovery process. The fact that you may have filed a motion is of no moment at this time, because that is an issue of discovery and not an issue regarding the filing of the motion. So you have the right to those documents. That's a discovery issue. And the 60-day period that I just opened up as discovery, you want to put that in a formal request and direct it to Mr. Murphy's office, and they're required to turn over documents to you that they intend to use at trial. Ma'am, I see your finger again.
What I'm trying to understand, I'm sorry. I filed for a subpoena on July 20th, 2022 with the court, and I don't have that. I never got an answer.
Yeah, okay. Well, I don't want to repeat myself over and over again.
I know what you're saying. All I'm asking, do I have to go through the court again, or do I just send them a letter?
You can send a discovery request. If there was a subpoena that was issued, you have to formally serve that subpoena on the other side in order for there to be compliance with the subpoena. I'm specifically ordering that the counter plaintiff turn over items that they may have in their possession that they intend to use at trial, intending to show that they have damages as they have alleged in their complaint. You're entitled to that. So I'm ordering that they turn it over. Now, what you want to do is you want to put it in, you don't have to put it in a subpoena, put it in a written document. If you wrote out a subpoena, you can take that and send that to Mr. Murphy's office. Specifically, what you're requesting is items, documents, information that they intend to use at trial, tending to show that they have losses as alleged in the counter complaint. And I'm ordering that they turn those over to you.
Okay.
All right. All right. Good day. And I'll see you on the next hearing day. All right. All the best to both of you.
Okay, I appreciate you.
Thank you, Your
All
Honor.
right,
Your Honor, we're ready.
Yeah, I got you. Just one moment.
Thank you.
I told you had priority. You don't need to be interrupted, jumping in there like that. All right. We're back on the record in 83-53. This is Goldman Sachs versus Erica Wilkes. Thank you, gentlemen, for taking the moment to go to the breakout room and drill down on some of these issues. Mr. Taylor announced ready, so I'm going to allow Mr. Taylor, if you will, to update regarding this matter, sir. You can.
Yes, and my bad, Your Honor.
No, I'm kidding with you, sir.
Your Honor, we're not really that far apart. So what we're gonna do is request 90 days discovery, and that'll give my client a chance to get a documentation and perhaps some additional fundings, and give us some chance to negotiate with the other side too.
All right. Makes sense to you, Mr. Brandon?
Makes perfect sense, Your Honor.
All right, got it, guys. Thank you again for taking the moment to kind of look at this, because that's communicating and what have you, always a good thing regarding this matter. So I'm gonna actually set it on a 60-day discovery track. I'm kind of liberal with those things. At the end, if you have been moving along and you need a little additional time, then we'll address that at that time. So I'm gonna have you come back on 12/14/22. I'm going to go ahead and set it for 10 o'clock a.m. on that date. And you'll get a written order of discovery from me. It allows open discovery through that period of time. I'm not setting any witness cutoff lists and things of that nature at this time. We'll address that at the pretrial date on the 14th of December 2022 at 10 o'clock a.m. The scheduling order will have in it a provision that allows the parties the opportunity to file motions, dispositive or otherwise, and set such motions for hearing in front of me on that same date, that is December 14th, 2022 at 10 o'clock a.m. As long as you file that motion and give the other party at least 10 days to respond, I'll hear it on the pretrial conference date. Again, hopefully this process allows you to continue to move forward on the efforts to try and get resolved. If not, the case will be positioned for the court to take the next actions that may be necessary herein. All right, anything else at this time?
Right. I'm sorry, Your Honor. I've got a bad connection this morning. I apologize. You were cutting out briefly, but it's December the 14th at 10 a.m. Is that right?
That's correct, sir.
Okay.
That's
Thank
correct. And that will be in the written scheduling order as well.
Perfect.
All right. Anything further, Mr. Taylor?
No, sir. Have a good rest of your day.
Likewise, gentlemen. I'll get that order
Thank
out
you.
to you. It'll be dropped in the mail today, so you'll get the scheduling order in the next few days. Good day to you.
Thank you, Your Honor. Take care.
All right. Thank you. All right. Nice meeting you, man. All right.
Yeah. Take care, Mr. Taylor.
Yep. All right.
Do I have Oakland Community College back at this time?
Yes, Your Honor. Matthew Kuipers on
This
behalf
is
of.
the subject. 1 second, Council. This is case number 2014-4698. Oakland Community College versus Karen Heel. That's Kamryn is that first name. The matter is before the court on an issuance of a subpoena. Council, for the plaintiff, please.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiffs.
Your P number, if you will, for the record, sir.
P71348.
All right, thank you, Mr. Kuipers, and good morning to you, sir. Glad that you're able to get back to us. Let me see if I have Cameron Hill on this Zoom. If you're on the Zoom anywhere, please say something at this time. I'm looking for last name Hill, reportedly living on Collingwood Street in the city of Detroit. If you're on the Zoom, please say something at this time. Counsel, it appears the defendant has not appeared in regard to the subpoena. Were you able to get the subpoena served, sir?
I was, sir. This is actually adjourned from September 20th. The defendant didn't appear there either. The subpoena was properly served, but seeing as how the defendant has not appeared here again today, we're actually just requesting a dismissal of the subpoena at this point.
All right. The court will go ahead and grant the petition to dismiss the subpoena at this time. All right, and that'll close out this matter, and then obviously if there's something else issued, we'll address that at that time. Thank you, counsel.
Thank you, Judge.
All right, the court now calls case number 21-173580. This is Tidewater Motor Credit versus Keisha Plummer. The matter is before the court, set on for a pretrial conference on today's date. Your appearance for Tidewater Motor Credit, please.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
All right. Thank you, counsel. Good morning to you. And do I have Keisha or someone representing Ms. Plummer on this Zoom? Please say something at this time.
Yes, Your Honor. Kelsey Sill, P83841, on behalf of defendant Keisha Plummer, who's present via Zoom.
All right, thank you. Thank you, Ms. Sill, and good morning to you, ma'am.
Good
All right,
morning.
Ms. Sill, why don't you go ahead and update us on where things are regarding this matter.
So plaintiff and I, our counsel for plaintiff and I have been discussing settlement. We do want to ask the court for a formal scheduling order today to give us a date for dispositive motions and to extend discovery through that time period.
All right, so I already set in place an order. I think it gave 60 days for discovery, and it also gave an opportunity for the presentation of any motion that you might have wished to bring before the court. You're saying that you need some additional time on the discovery in this matter?
Yes, we need additional time for both. We have
Your
been
Honor, I apologize. I don't mean to object. I don't mean to interrupt.
Counsel, I'm coming to you. No question about it. We're never one side here. Ms. Sill, you may continue.
Yeah, we need additional time to file motions and then also for discovery, just because we've been communicating back and forth about discovery, and we have some communications, but I want to just be sure that all documents have been received by both sides.
All right, thank you. Mr. Counsel, your name's not on the screen. Give me your name again, if you will.
Apologies. Jay Lazar on behalf of the plaintiff, P69480.
All right. Go ahead, counsel, in regard to this matter. Go ahead.
I was just trying to, if it helped at all, just point out that I'm on the same page here, and that again, me and sister counsel have been nothing but working well together. We just had some new information come to light between the two of us recently that I think will go a long way to settle the matter. I don't think anything but a little more time will help. So I didn't mean to interrupt. I only meant to just say that we were all on the same page.
Gotcha. Yeah, just, with this, with this whole Zoom system in place, some other sound comes in, it can get real crazy. So I try to just stop everybody and just stick with one and then go to the other. So that's really what drives that a little bit.
No problem.
All right, so I see that, and that looks like the direction that we need to go on this matter. So I'm going to go ahead and set it out. I'm thinking 45 days. And I'll take another look at it. That's not going to be in the nature of any type of penalty or anything. But what happens is that as long as the parties are talking on the same page regarding where discovery is, then generally speaking, my position is to, is that things are moving forward and that, you know, we give you a bit of leeway. So I'll go ahead and set it out 45 days, extend the discovery order. Then that due date about 45 days out is going to be
November 29th.
November 29th, 11/29, 22 at 9:45 a.m. And that date can also be used as a date for hearing on any motion that you might file before the court if you wish to file any motion. So note that date. And all you need to do is to give the other side, the opposing party, 10 days notice that you want a motion to be heard on that date, and I will hear it on the 29th. That can be dispositive or non-dispositive, and I know that I'm shortening the dates, the time that is normally allowed under the court rules. So if you file a motion for some disposition, for example, if you allow the other party at least 10 days to respond to that prior to the hearing, I will hear it on the 29th of November 2022. So that's going to be in the order extending the scheduling order under paragraph number 6. And the new date, as I've indicated, is 11/29/22 at 9:45. I'm hoping that you can get it resolved. Looks like you're making some progress, and I wish both of you well. Anything further at this time?
No, Your Honor.
No, Your Honor, I appreciate it. I, if possible, have one other hearing, and I do see the defendant in the Zoom room.
You have another case in front of me?
Yes, Your Honor.
All right.
For prestige.
Just one moment. Let's get to that.
Okay. Thank you.
Let me see which one that is. All right, then which case is that, counsel?
Last three is 557. It's Prestige versus Buchanan.
All right, got it. Now, you were saying that you wanted to talk in a breakout room. Is that what you were saying?
Oh, no, I think we're ready to have this one called. If that's okay.
All right, gotcha. All right, this is case number 17-1255557. This is Prestige Financial Services versus Angela Buchanan. The matter is before the court on a motion for installment payments. Looks like there's objection to a writ of garnishment. It seems to me that was set on a, well, strike that. I only see a motion. Oh, yeah, I do see objections. It looks like the objection, well, that's from a previous time. All right, your appearance at this time, counsel.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Thank you, Mr. Lazar. All right, and do I have Angela Buchanan on this Zoom? Say something, ma'am, if you're here.
Good morning, Your Honor.
Good morning to you. Welcome to this hearing. And I do see that you filed a petition for installment payments regarding a judgment that was entered, and looks like that judgment is like 26. Let me make sure I've got the numbers right on that. Yeah, he's saying that well, there's $7,600 is a judgment in this matter. It looks like. And how much are you asking to pay, ma'am?
Well, Your Honor, a lot of things has changed in my life. That
let me stop you there. Let me stop you there, and I'll hear you on those in a moment. Well, let's drill down on the specific question. When you filed your petition, you asked the court for the opportunity to pay $150 per 2 weeks. So $300 a month is what you asked the court to do.
Yes, please.
To change. Let me, ma'am, please.
Okay.
You're saying that things have changed, and you like to ask something different than that. Is that correct?
No. Initially, I did have an installment plan of $200. I missed one payment, and then they start garnishing my check again.
Exactly right, ma'am. I know all of that already. You're trying to get back on the payment plan, and you're asking for a lower amount. So I'm asking you, is it in fact correct that you're asking for the opportunity to pay $300 a month? That's what you're asking for?
Yes, sir. please.
All right, council, I know that there was a previous installment order, and the defendant did not keep that, and if she doesn't keep it, what happens is, of course, the order gets set aside and a garnishment issue. That's what happened in this case, is that a garnishment issue, the court did stop a previous garnishment or suspended it, and then it got back in place because of the fact that the defendant didn't pay as she was directed to do. Go ahead and tell me what your client's position is in regard to this matter.
Your Honor, my client's position here is that she has had the opportunity for the installment plan. It didn't work out. She only made 4 payments since January, so I don't know how she under the misunderstanding where she thinks she only missed 1, but I am showing she's only made 4 payments on Your Honor's installment plan from January. We were here then and did this. So being that today is October, that roughly sounds like about 6 payments she missed, 5 or 6.
No.
But regardless of that,
I'm sorry.
You can't do that, ma'am. Not at all.
I'm sorry. I'm
I
sorry.
take it that some of those missed payments that you're calculating now, counsel, are secondary to the fact that the installment order was set aside. But your point is that at the time it was set aside, there was more than 1 payment that was missing. That's what you're communicating, correct, sir?
yes, Your Honor. At the time it was set aside, there was at least 2 payments, if not 3 missed.
All right, thank you, counsel. All right, so, ma'am, the challenge is that the other side is opposing the court issuing any type of installment plan because you didn't keep the other one, whether it was 1 missed payment, 2 or more. And so what that does, it puts you in a position where it will garnish your wages at 25% of what you make. So you get paid every 2 weeks, is that correct?
Yes, sir.
And how much, you've been hit with the garnishment, how much is taken by way of the garnishment every 2 weeks?
It's usually close to $400 taken on my check, sir. And I'm in eviction now because of this.
And I don't mean to be harsh about it, but when I gave you the opportunity to pay that way, that's the whole point, is that you not put yourself in a position where you end up in that kind of position now.
Sorry.
Yeah, go ahead. I'm listening to you now.
It went left. When it went left with the installment payment, sir, of course, the world that we live in, I'm not making excuses, but the landlord that I had sold the property that I was living in. If you could look at it in your records, I just recently had to move because the new owner just wanted to buy the property I lived at to sell it. So that is why I end up missing the 1 payment that I do. I do have my receipts from when I paid them. I was paying them on time every month until that occurred. Life happened. And I did call. I called and I tried to speak with their attorney, Attorney Lizo, and explained what was going on and why I was going to be late on that payment. And I asked him would it be possible for him. And at that point, I found out that next paycheck, he had already garnished me. I did try to do the best I can to continue to pay. Now that I'm in a new place, which now just got here, and I'm behind on my rent because of this. I do work every day. I am a widow. I lost half of my income because my husband is no longer with me. And I have been struggling. I do want to pay what I owe, sir, but I don't want to be in the street trying to do it. I know I can't afford to pay what I'm asking you for, and I would never be late, Your Honor.
All right. Yeah. So I hear everything that you're saying, and I want you to understand something about a partial payment order. That is an opportunity to have an alternative way of paying, because under the law, after 21 days of entry of that judgment, you're required to pay it off. So anything that's short of that is like a special arrangement to pay it. And those are not rules that I made up. Those are the rules here in the state of Michigan. So when you get a partial payment order, keeping that, I know that we all know that life happens, but keeping that, that's to your advantage, because if you don't pay what's under the order, then you end up paying $800 a month. Because, I mean, that's the challenge. If you run into a situation, what you should have done was file a petition to the court, asking the court to adjust it or asking the court to change it before you missed any payments.
It happened. I understand, but I tried to, I'm
Yeah,
sorry.
you listen to me.
I'm
Ma'am,
sorry.
look, you didn't try to do anything when it came to filing something with the court. You may have tried to talk to somebody on the other side. You didn't file anything with the court. You did.
Yes, sir. That's correct,
So
sir.
I want you to understand it now, and I'm not trying to give you a hard time, but what I'm really trying to get you to see is that as tough as this may be, I don't, of course, I don't like the idea of you having to pay $800 a month. That's gotta be tough. 25% of anybody's salary being taken has got to be an incredible tough thing to have to deal with. But given the opportunity for a partial payment, is quite the thing that you have to exploit so that you don't put yourself in that kind of position. What I'm going to do, counsel and ma'am, I'm going to go ahead and I'll allow the installment order, but I'll review it. I'll review it in 60 days. So that council will not have to file anything to set it aside or whatever. If the payments are not being made, I'm going to set a hearing date on this. I really want the payments to be made, but if they're not being made, just wait for the hearing date. I'll set it aside and I'll allow the writ to be back in place and stay in place, and there won't be any relief in the future. I really want you to be able to keep that as best as you can, as tough as things are. You're right, but we're in some tough times, but you don't want to be paying $800 a month. I mean, the only way that you're going to be able to do that is to keep up with the payment arrangement. So at your request, I will adjust and amend the amount to $300 a month. And you can pay that in whatever installments as you before it was $150 every 2 weeks or $200 every 2 weeks, whichever way you want to do it. I will commence the installment payments on the 4th of November, 11/4/22. I'll suspend the garnishment right away. And then on the 4th, you start making your payments in this regard. And I'm going to set a hearing on the 14th of December at 9:30. December 14, 9:30 will be a review hearing on this matter. Because I want to see if this is being taken care of. I know that's in close order, but that's because I don't want to put it too far out. And I'll take a look at it at that time. I'll probably set it for another period after that and take another look. Because I wanted to work for Ms. Buchanan, but I know it has to work for the plaintiff that has a judgment in this case. So I'll take a look at it. The hearing date again is December the 14th at 9:30 a.m. I'm issuing the order for installment payments today and for the stopping of the garnishment, and I'll get that out to the respective parties right away. Ma'am, if you'll put in the chat your email address, the court will email a copy of the installment order and the suspension of the garnishment that you can take to your employer and have them to stop withholding. Again, note the date. We'll be sending out a notice, but that next date is the 14th of December, 2022 at 9 o'clock a.m. All right. I wish both sides well, and I'll see you on that day.
Your Honor.
Thank you. Thank you, Your Honor.
I just want to make one quick clarification because the first time you said 9:30, the second time I heard 9. Is it 9 or 9:30?
It's 9:30.
9:30. Okay.
12:14, 9:30 a.m.
And then if everything is okay, can we just fax a letter to Your Honor just saying that we're okay, we don't need the hearing, or do you want us to appear regardless?
And that would be a wise thing to do. Thank you, counsel. A letter faxing to the court would eliminate that date and just make sure that Mr. Buchanan also knows that that you all are good and that you don't need that date. And likewise, to the extent, because I'm exercising some control regarding this case, to the extent that there's a problem beyond December, then you can fax a letter over to the court, asking the court to set a hearing. And I'll set a hearing in short order so the parties can come to the Zoom and I can see what's going on.
Perfect.
So I'll move this along. You understand that, Ms. Buchanan?
Yes, I do appreciate it. Thank you so much, Your Honor.
And if I may real fast, Ms. Buchanan, I don't want you to say it here for the record with everybody here, but when you make your first payment, if you want to send a little note with your phone number, I don't have a good phone number for you. So if you want to put a little note with your phone number in with your payment, I'll put it in the system. So that way, like Your Honor said, we'll let you know that if everything's okay, we don't need that hearing. So if you don't mind, just send us your phone number with your first payment.
Okay, and correct again, this starts on
Oh,
November the 4th, correct?
Yeah.
I'm gonna go ahead. I'm giving you a notification for breakout room number 2, where you
Perfect.
can maybe, you can work on those
Okay.
things now. So go ahead.
Thank you, Your Honor.
Once you're done there, you can leave, but go ahead and click into breakout room number 2 so you can deal with logistics. All right.
Thank
Good
you.
day.
Perfect.
Have a good day, Your Honor. Thank
All
you.
right.
Be safe.
All right, the court now calls case number 18-172932. This is Johnson Financial Recovery Group versus Tamika Matthews. The matter is before the court set on for a hearing on today's date. It looks like this has to do with a garnishment, garnishee disclosure. Your appearance for the plaintiff, Johnson Financial, please. Do I have someone on Johnson Financial? Tamika Matthews, Care One Senior Care. All right, looks like.
Ready, Your Honor. Robert Goodman appearing on behalf of the plaintiff.
All right, thank you, Mr. Goodman. Your P number, if you will, for the record, sir. Give us your P number, Mr. Goodman.
P55670.
All right, thank you, sir, and good morning to you. I've called for Tamika Matthews, and I've also called for, looks like Care One Senior Care LLC as a garnishee defendant in this matter. Nobody has responded in that regard. Talk to me, Mr. Goodman.
Judge, so this in this case, the garnishee defendant, there was a judgment entered against the garnishee defendant for failing to comply back in November. Despite entry of that judgment, the court clerk dismissed the garnishment, dismissed the garnishee defendant improperly. So this was filed to reinstate, set aside that dismissal so that that judgment remains in place. We filed a motion which detailed in great detail what happened. This is not the only case in which the court clerk is doing this. I did have a conversation with Mr. Roscoe in the civil division. There's some training that needs to be done with the civil clerk that they're working on, but the case was improperly dismissed against the garnishee defendant. We're asking that that be set aside.
Yeah, it seems that there may be something of a glitch in the system when there is a generation of an additional party in a separate judgment. I don't know what the issues are there, but it does appear in this matter that the motion that addresses the dismissal of the garnishee, of the garnishment and of senior care, that was imprudent. Accordingly, I will grant the motion, and the garnishee defendant will be reinstated as a party to this matter, and thus the judgment entered against the garnishee defendant stands in full force. So ordered.
Thank you, Judge. I do have a proposed order behind all my exhibits and proof of service. If the court can sign that, that would be great.
I was looking for it. Let me see if I find it here. And if not, you can certainly email it and we'll get it taken care of. So.
Thank you. Yeah, we put it as the very last page so it can be ripped off easily. It's behind the proof of services, the exhibits.
Well, the only thing that I see behind the proof of service there's another proof of service. So just if you will,
Be happy to email it.
yeah, go ahead. I got the notice of hearing and everything, but I don't see a proposed order. So do you have the email address, or can I give it to you now?
That'd be great if you could give it to me now.
All right, that's Latifah, LATIFAH dot, last name is Hunter, HUNTER, at 3636 CH 36 District Court.org.
Thank you, Judge. I got it.
All right, you get that over to us, and we'll sign it and get it right back to you soon.
Thank you. We'll email it today. Thank you.
All right, thank you.
Sorry. So Mr. Cox, we're gonna run. That was just the other judge in the other courtroom.
This is case number. Yeah. We'll just wait until that motion is done. Case number 21-169-362. This is April Duran versus Best Deals Auto Sales Incorporated. The matter is before the court. Looks like on settlement for pretrial. Your appearance regarding this matter, please.
Good morning, Your Honor. Brent Credible appearing on behalf of plaintiff Best Deals Auto Sales, well, defendant and counter plaintiff, excuse me, P75845.
All right, thank you, counsel, and good morning to you.
Good morning.
And April Durham, are you on this Zoom?
Yes, sir, I am. Good morning, Your Honor.
All right, good morning. Good morning to you, ma'am. All right, so counsel, go ahead and update me. I think.
Sure.
Go ahead and update me regarding this matter.
Well, Your Honor is correct. This is scheduled as a pretrial. I think it was sort of scheduled as a final pretrial. We have had a few hearings previously, the last of which was adjourned because Your Honor was not available. But it's, in addition to being a pretrial, it's also, motion date. Looks like both parties filed motions to be heard today. And so, my office filed a motion for summary. Ms. Duran also filed a motion. And so I guess I'm prepared to argue those today, or whatever the court would like to do.
Let me ask a couple of predicate questions real quick. What was the cost of the warranty that was attached to the purchase of this particular vehicle? There was a purchase agreement, and there was a warranty that was purchased as a part of that deal. It looks like this is a situation where there was a fallout regarding getting repairs under the warranty, and then subsequent to that, defendant strike that plaintiff made some efforts to get the vehicle repaired elsewhere, was not able to do so, and then as a reaction to that, it appeared to stop making payments. The contract, the car was repossessed and then sold at auction for $500, and then the rest of the snowball effect. So kind of, what was the cost of the warranty? This whole package?
The cost of the warranty, Your Honor, was $595. And I represent numerous clients. One other client I know of that uses a similar warranty to this, and the warranty is not specific to my client, though generally my client would do the repairs. It's ASC. I couldn't tell you off the top of my head. I'm looking for the actual document to tell you what those letters stand for. But essentially, there are, many other dealerships or service centers, what have you, that are work in conjunction with this ASC warranty, and they have sent me numerous examples of people taking vehicles with the same exact warranty that Ms. Duran had and getting it fixed elsewhere. But But yes, that's the warranty that was provided.
All right. And this vehicle was purchased, and the mileage on the vehicle pursuant to the agreement documents at the time of purchase was 140,000 plus miles at the time of purchase. Correct, counsel?
That is correct, Your Honor. I see the same thing.
So, and I'll come back to you, Ms. Durham. You said you only paid $2,500 for the vehicle. The agreement says that you purchased the vehicle for approximately $6,000 and that you purchased it pursuant to a contract with interest on the contract. Is that correct, ma'am?
Yes, sir, I believe so. I gave 20. Yes, sir.
Ms. Durham? You're
Yes,
away
sir.
from your- I can't hear you now. Go ahead, ma'am.
Can you hear me?
I hear you now, yes.
Okay, I'm sorry. Yes, sir, I did put down 25. They said that was the what I needed to pay, then 150 2 weeks.
Okay, so, but the purchase price, I'm looking at this contractual document and it tells me that there was a purchase price with taxes and all that seemed to be in the nature of $6,193.28. You put down $2,000. You financed the rest at almost 25% interest, and that left a balance of $6,193. It looks like.
No, they didn't hike up the prices. I got my agreement here. It don't.
Yeah, Your Honor, the 6193 amount would be what she would have paid. So that would include the finance charge. So the amount that she financed was the $5,309.70.
Right. And
I just want to.
The interest on that was $883, bringing the
Correct.
total to $6,193. Correct.
Correct.
Yeah. So I'm looking at the document, ma'am, that has your signature all over it, and it says that the total of payments or the balance that you would be paying over time on this was $6,193.
Well, I was under the understanding of $5,000 I was gonna pay. I put down 2,500. They told me to make the rest of the payments. I owe 5,000 something dollars. I guess with taxes now, I don't know what, but I was known for $5,000. They turned around.
You put down under the agreement. It shows that you put down $2,000.
What was 2,500? I have a receipt for 20.
Doesn't have that. Maybe the 25, the other 500 went towards the warranty. Is that what happened?
Okay, probably. That's probably what happened.
Okay, all right, yeah, because under the contract, it only shows the $2,000. And then it shows various other charges, license and finance charges.
Well, I would imagine we're paying all that money the first day to ride off my transmission bus. The first day riding off the line, my transmission, and that's what made it all just so bad.
Wait a minute, ma'am. We're talking about the contract, and sometimes you talk to me and I can hear you real clearly. Other times I got this boom boom sound in the background. What's going on?
I'm sorry, I don't know.
There's a lot of interference, Judge. I'm having a problem too.
I'm sorry, I don't know what is the speakerphone. I got it on speakerphone. My house is quiet.
All right. I guess my problem is that there are times I can hear you real clearly, and then it seems like you move away from the microphone or the phone or whatever it is you're talking in.
Okay. Sorry.
All right. So under the contract, it looks like there was a substantial balance that was going to be paid over time, and it seems to me that based on the things that you filed in front of me, ma'am, that when you couldn't get the relief under the warranty, you made the decision that you would stop paying for the car. Is that correct?
Yes, sir. One payment. Yes, sir. One payment.
All right, got it. All right, so counsel, how is it so then, this car is repoed, and obviously there are repossession charges and what have you, but it's sold at auction for $500. That's what it.
Yeah, Your Honor, I believe the vehicle ended up being salvaged. My client does have a service center on lot. So generally, if they can fix it and resell it on their lot, that's something that they will do. That's a cost benefit analysis that they do, and I'm not a car guy, so I can't speak to it. But if they salvaged it, what I found is that was, for whatever reason, the best that they could do on the vehicle.
All right, so yeah, and it already had 145,000 miles on it, so that has to be taken into consideration. You know, this is a car that's way up the road. So Edge, what are you asking for by way of judgment in this matter, counsel?
I mean, well, Your Honor, what is our complaint? I want to say it's the deficiency balance on the contract, Your Honor. It's
right. And I want you to kind of tell me that number again. So
it is $4,256.40 plus, you know, interest, cost, attorney fees.
All right. So in considering the motion in this matter, the adverse claims, et cetera, that are brought in this matter, and first of all, Ms. Durham brings this action before the court, basically suing because she does not get relief under the warranty, because there's really not there's really not a whole lot that can be said about the contract. The contract is a contract. The parties agreed that she would purchase the vehicle, and she agreed to purchase the vehicle. Some things happened afterwards where she wanted to get it repaired under the warranty. She wasn't able to get it repaired. She stopped paying. That's a breach of that contract. She's not entitled to void the contract because there was something ultimately wrong with the car, because the law doesn't allow her to do that. It seems, no, you're not talking now. No. It seems to me that there would be certainly some offsets from the amounts that are claimed under the counterclaim, given the fact that notwithstanding the fact that the agency does repairs, that they would not do this repair. I understand that there was a fallout, and then the plaintiff says that she was not able to get any relief at other places. At a minimum, she would likely offset any balance that is due with the amount of that warranty. Moreover, it seems to me that the cost benefit analysis that was made by the counter plaintiff in this matter to decide that the value that would be applied to this vehicle is $500 seems to be a little bit untoward in this case. It might need to be considered a little bit. Here's what I'm getting at. Ma'am, it looks like to me that what happens in this case is where Ms. Durham would like for the court to void the contract. There's no legal basis for the court to void the contract. She does seem to raise a reasonable issue before this court that if she owes money, that she might be entitled to an offset of money that she owes. She agreed to purchase the vehicle, and so she's responsible for the purchase price of the vehicle, subject to offsets. That's what this case looks like to me. I could I could drill down on what the numbers should look like. The parties probably need to take a moment in the breakout room to see if you can talk about this and get it resolved. There's nothing here at law that will allow this court to avoid the contract. There's nothing there. So we start there. That there is a contract. The contract is breached. That there are some extenuating circumstances that have been brought before the court that may entitle her to an offset for some of what is claimed by way of a CPA judgment. And those offsets will begin with that warranty. I just under these circumstances, she would be entitled to. I would probably determine that she'd be entitled to an offset of the cost of the warranty. And then the other consideration would be whether or not the $500 assessment on this vehicle was a fair assessment under all of the circumstances, where that determination is made exclusively by the counterclaimant. So you need to come up with a number that, you need to see if you can come up with a number. If not, the court will come up with a number that works for this case. I'm going to send you to this is not a force issue, but I'm going to send you to a breakout room in light of the considerations that the court has regarding this case, and see if you might be able to talk about this and reach a resolution. If not, I will weigh in on it a bit more, because there are opposing motions, and try to make a decision as to what should happen in this regard. All right. So I've sent you a notification, Ms. Durham, also counsel, and I know that you've been waiting up here this morning. Go ahead to the breakout room. Good. And see if we can have any discussion on the things that the court talked about, and then come back in and we'll go from there.
Will do. Thank you, Your Honor.
Thank you for taking a moment. All right, the court now calls case number 22-183-020. This is Credit Acceptance Corporation versus Talisha Ingram. The matter is before the court. Looks like an adjourned date of hearing regarding this matter. The issues are joined by way of contest, but I did not set a schedule for a previous date. For the plaintiff regarding this matter, Credit Acceptance, your appearance, counsel.
Judge, may I please court? My name is Attorney Richard Rusum. I'm 35222. I am the attorney of record for the plaintiff.
All right, thank you, Mr. Rusum. Good morning to you, sir. I'm looking now for Ms. Ingram and Ms. Destiny Willis, it looks like. Tell me if you say something if you hear, please. Talisa Ingram and or Destiny Willis, if you're here, please say something. Mr. Rosen, have you had any contact with either of those persons on this day, sir?
No, Judge, I had to have no contact, and based on the notice going out today, this is therefore, I would ask for a default to be entered, and I will file that forthwith and then duly follow up with a default judgment under the court rules.
All right. The court will then make the finding that where defendants have not appeared for this hearing, the court will make the finding that defendant is in default and that defendants are in default, and will receive, will enter the default at this time. The court will also enter a judgment upon that default upon proper presentment. So ordered.
All right. Thank you, Judge.
Thank you, counsel. One moment. All right, the court now calls case number 21-170662. This is Credit Union 1 versus Ebony Parker. The matter is before the court on objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered on the 26th of April 2022. That judgment is for $2,579.47. The plaintiff sought enforcement of that judgment by filing a writ of garnishment as it relates to the DMC, and that matter is before the court. All right, your appearance for Credit Union 1, please.
Good morning, Your Honor. James Zellin appearing on behalf of the plaintiff, P69241.
Thank you, Mr. Zellin. Good morning to you, sir. I'm looking now for Ebony Parker. Ms. Parker, if you're on the Zoom, please say something at this time, ma'am.
Yes, Your Honor, I'm here.
All right. Good morning to you, Ms. Parker. And
good morning.
These are your objections to the writ of garnishment. And you noted on your objections that you were never served and that the garnishment should not be effective for that reason. What do you mean when you say that you were never served? Ma'am, tell me about that.
Well, I never had any paperwork from the court about me getting garnished. The only way I found out is when I looked at my check and I seen the amount was not what, it was lowered. So then, like a week later, after that, I got something from my job stating that I was getting garnished.
All right. So yeah, the garnishment would be something that would come by surprise. You would not get a notification that you're going to be garnished, but that is a surprise item. What should not have come as a surprise was the judgment. A judgment was sent out to you in April of this year, indicating that a judgment was entered for $2,579.47.
Right. So that paperwork, I'm sorry, Judge.
Go ahead.
That paperwork wasn't received. Okay, so when I went to the courthouse to do the objection, I looked on like the paperwork that I got, and it had the address of 1942, and that's not my address.
All right, yeah, I see, and so yeah, I see that the rest of the file has 1941, and it shows a service of the documents back in February, and you never responded to the complaint that was served at 1941 and noted. But you're right on the judgment; it has 1942. It does have the correct apartment number 102. All right, so I don't know that is a sufficient challenge as it relates to the garnishment. I guess the underlying issue here is that what are you going to do about the judgment? I can probably find a way to get you off that garnishment. How much is being taken from you on a each
Okay,
payment?
so they have took 2 payments so far, and the first payment, it was like almost $400. I think it was like $392. And then the second payment that they took out was, I'm sorry, I think it was let me look at my check stub.
So
It was $282.59.
Okay. So, and you get paid twice a month, is that correct?
Yes, biweekly, yes.
Okay, so basically these garnishments are hitting you for.
They're hitting me hard.
They hit you for about 600 or so a month, correct?
Right. So yeah, I mean the first payment actually it was almost $400.
Yeah. So yeah. All right. So here's the thing. I mean, if these payments are released and get to the other side, it means that on the $2,500 judgment, you roughly will have paid almost $600. So how much can you pay a month to resolve this so that you don't have a garnishment?
Is it possible if I could pay like is $150 a month? Is that too less or?
No, that's a good amount now. If you want to pay $150
Okay.
a month, and you're going to keep
I can
that-
pay it like I can know if they can have an arrangement where they can take like 70, out of each payment, or I can just pay it once a month. I can pay something like that, but I can't afford this right now. This is too much. Food is high. Rent. I'm in a hole right now.
I hear you.
Off of these 2 payments.
I know you wanted to tell me all that, but I already know that, right? I got you. Let's see what
I know, Judge.
All right, let's see what Mr. Zellin has to say about it. Mr. Zellin, sir.
It's an objection to garnishment. I don't think she has a valid objection to the garnishment. I think the court has covered that. But with regards to installment payments, if the court chooses to order $150 a month, I'm not going to vehemently object to that.
Yeah, I think that's a reasonable way to deal with it, ma'am. So what I'm going to do is, as it relates to the objections, there's not really a valid objection that has been raised in this regard. So what I'll do is I'll find an objections is valid. Any funds that have been previously taken, I'll allow those to be released to the plaintiff. So they'll get that to apply towards the judgment, and then I'll suspend the garnishment, and and then I'll allow you to start making the payments on your own at $150 a month. And your first payment will be on the 4th of November.
November 4th.
11/4/22 will be the first date for your payment of $150.
I'm sorry, Judge. You said November the 4th, right?
That's correct.
Okay, thank you.
And I'm going to suspend the garnishment. I'm going to suspend the garnishment in this matter, and then you start making that payment voluntarily. Now, how you go about it, I'm going to take a moment for Mr. Zellen to communicate to you exactly what you need to do. I'm going to put you in a breakout room just so they go over those details. If you will chat your email address, we'll get a copy of the order stopping the garnishment over to you, and then a copy of the order for the installment payments as well. You understand, ma'am?
Yes. I'm sorry. How do I do the chat with the email? I'm not really confused.
If you're looking at your device, it should have a place where you can chat it, and if you can go click on that chat, it will allow you to put it.
Okay, because I'm on the phone. I'm not on the Zoom.
Oh, okay. Yeah, well, you wouldn't be able to do it in that matter. So what I'm going to do is I'm going to have you and Mr. Zellen to talk about the logistics of making your payment, and then when you talk, that'll be in a private setting. So give Mr. Zellen your email address. Mr. Zellen, you will chat her email address with you, sir, once you get it. Would you do that, sir?
I can do that, Your Honor.
I really, really appreciate that. So, ma'am, you're getting a notification from me now to go to the breakout room. And Mr. Zellen, I'm sending that to you as well, sir. And I appreciate your time. Get that chatted to me.
Thank you.
All right, this is case number 22. 242808. This is Monique Teal versus Mo's Advanced Tech Auto. The matter is before the court. Look like it's set on for a trial on today's date. Let's see. Do I have Monique Teal here today?
Yes.
All right. Good morning to you, ma'am.
Good morning.
All right, and Mo's Advanced Tech Auto.
Good morning. Scott Murdoch, P46424, appearing on behalf of the defendant in this case. We also have present a representative for Mo's Advanced Tech Auto because this was listed as the trial date. However, I just received I believe yesterday, a notice setting another pre-trial hearing date in December.
Really?
I had actually filed a motion for more definitive statement of which there wasn't a hearing, but I did file an answer because I did get some more information from Ms. Till to at least get the gist of what her claim was.
Filed an answer, that's why. Yeah, filed an answer. You said another date on it, but.
So you said the other day because you filed.
Yeah, I filed an answer.
Yeah, so yeah, you're right. Another date was set because of the answer that was filed regarding this matter. So, yeah. And I do see, I don't have a complete file in front of me. I do see a motion for definite statement. But the date got changed because subsequent to that time, there was an answer filed in this matter. So it looks like, then, council, I'm gonna have to set this on another date. Well, let's kind of see if we can drill down on this a little bit. Let me just do one thing just before we do that. Mr. K, I see that you're back, sir. Come on back in. I was gonna take a chance on pronouncing your name, but I couldn't get it all together in that moment.
That's
And
okay.
I get that, and I'm coming right back to you, Mr. Murdoch, and ma'am, I'm coming right back to you. I
Okay,
see that-
thank you.
I see that Ms. Durham is back and counsel for Best Deals Sales are back. I sent you out with a particular agenda on this matter. And I want to know, there are cross motions we're going to do in this regard. I want to know where things are at this point, counsel.
We weren't able to come to a resolution, unfortunately, Your Honor. So I apologize. We did give it a chance, and unfortunately, no resolution.
Got it. All right, Ms. Durham, what did you want to tell me at this point? I'm sure you understand the posture of the case, but anything you want, don't talk about numbers, but what did you, anything you wanted to say at this point, man? Ms. Durham?
Doesn't look like she's back.
No, I'm sorry. Miss.
Can you hear me?
Miss Teal. Miss Teal is the
Yeah.
president.
My phone is low.
Hold on a second. I'm mixing this all up. 1 second. Just let me stop for a moment. Yeah, I'm looking for Miss Durham. Miss Durham.
Yes, sir.
All right. Miss Durham, anything, you heard what council said regarding this about you guys trying to work out a resolution we're able to do. So anything you wanted to bring to my attention at this time?
Yes, sir. Due to me with the car and every situation, I missed one payment. I do apologize for that, but the car wouldn't go over 20 miles per hour. Transmission was messing up. I was faithful on my payments because I stayed right down the street from them. They had an auto shop right there. And so I thought I was doing a good thing, stepping out, buying me a car, spending $2,500. They didn't even want to give me $500. They didn't even let me know where the car was being auctioned off at. They didn't let me know any information. And then they didn't honor my warranty because they said I had an attitude. Now, I've never heard anything in the contract said because somebody had an attitude, drove off the lot, transmission bust the first time you get the car. They've been trying to fix the car ever since. I lost my job. There was a lot of things that happened during this. And $2,500 is a lot of money for a single woman to come up with. So, Your Honor, it's just the fact that they want to now sue me, and then not even just to even try to honor the fact that nobody would fix the transmission. I thought I can go right down to the service center, right directly down the street from my house, and get it fixed. And they told me because I had an attitude, I called the police just to make sure everything was documented. And they told me just to make sure I went down to the courts and filed. I've never filed in my life against anyone, but I know from here on out, I will always file a case against somebody that has wronged me or done me wrong. So that's all I wanted to let you know, Your Honor.
All right. So, the challenge here is how the law protects and honors contractual agreements that parties enter into. That's the biggest part of this is that even when things break down, there are contractual documents that parties have entered into that give rise to certain things that they may have. And you signed a contract to purchase the vehicle. The one option that you did not have was the option to simply not pay on the vehicle, and I would suspect that that's kind of a legal mistake that you made. On the other hand, I've been able to look at some things in this case because both parties, I think, have just laid it out before the court kind of what happened, and part of it is that for some reason you were not able to get that warranty to do what that warranty was supposed to do. So at the very minimum, I would think that you have to get reimbursed for that. And then furthermore, I don't think that you got as much credit that you should have gotten for the vehicle that was turned. But the big thing here is that the contract that you signed was a contract that establishes the amount of expectation that the parties had. So that contract was, we went through the numbers. It was in the $5,000–6,000 range, even after you put the 2,000 down, et cetera, et cetera. So that's what brings this down to. If I give all consideration of the various things that you mentioned in this case, and I take into consideration that the parties had a contract, then there still ends up being a balance. That's what the problem is here. You said something about a $2,500, something about $2,500. Certainly, if in this case where there is some indication of a $4,200, I take $500 off of that for that warranty that caused problems here. If you got this down to $2,500, I don't know how you would be able to get that lower than that, even because what we're talking about now is offsets. And if you had in this case something to offset the entire balance, then the case will work out that way. But I don't know that you have offsets that take you to $2,500. But if they're willing to resolve it at that amount, then and I haven't discussed that with anybody, but that's what the parties are talking about. That's a fair and reasonable way of resolving it. Obviously, if you resolve it at that amount, you don't have to pay all of that at one time, but pay it on a partial payment to try to get it resolved. But if you got it at $2,500, then I don't see how you're going to get better than that. Because again, if the court gives you consideration on this, I would reimburse you for the $600 for the warranty. That would bring it down. That would bring it down to $3,600. I would probably take off another $500 for the resale of the vehicle, because they only got $500 for it. But in worst case scenario, I would say it was maybe $1,000. But when I talk about a vehicle that already you purchased it, that's the crazy thing about it. You purchased it, it had 140-something thousand miles on it.
That's why I will never buy a car no more without a man coming with me. I will never purchase another car, ever.
I don't want to give men that much credit, because I have cases here where men do the same thing. They purchase a car with a lot of miles. But what it is, it's not necessarily a bad decision, but it's a risky decision for everybody involved.
That's why I put the warranty. That's why I put the warranty, thinking that I was doing good.
That was the smartest thing that was done here. And that's why if you did get satisfaction on the warranty, regardless of what the other side is saying, my determination would be to reimburse you in total for the warranty cost. But then you're still stuck with what the overall value of the contract was. In this case, if you can get from $4,200 down to $2,500, I can't say that you should about this case at that amount. I don't know how to get lower.
Well, Your Honor, when we first entered this agreement, we first went in, they said 0. They just told me to drop the case. Only because I pursued it is now they want money. First, they was going to drop the whole case, told me just don't file against them, and we're going to drop everything. And I decided to fight because I've never really fought in court for nothing. But for me to spend all my last little money waiting on unemployment a whole year to be able to go buy something that I felt was of value, and then I buy $600, I don't feel I should have to pay another $2,500. If we're gonna walk away even, we walk away even. I don't get nothing then. Then to sit here now and make payments, and I'm still not working. I'm back from square one, lost my job. So where do they even give any benefit of accountability of what they did?
Well, there are some accountability issues, and those are really the offsets. The biggest problem here is that I have to hold you accountable as well as hold them accountable, and you're accountable for what you signed and agreed to, and that's what the bigger issue is here. If you got something in writing where the other side told you that if you don't pursue this, and they won't pursue it, then I can enforce that.
It's on our call in when we did it in the breakout room.
It was negotiations that she's referring to, Your Honor, and I'm
sorry, sir. What did you say?
It was negotiations between the parties once the case was already filed, Your Honor. It's not. Yeah.
Yeah, it's in one of our breakout rooms. So I'm quite sure that's probably recorded.
Okay.
Where he told me the first time we started that they wasn't gonna
And
file anything
obviously,
against
that's
me.
not appropriate to bring to the trier of fact.
I can't really talk about that part of it. What I can say is that counsel, to the extent that in this case, and I have no idea, but to the extent that in this case, the party's discussion at any point was that you walk away, will walk away, then anything beyond that at this point would seem to be an issue of punishment. And that's not a reasonable way of going forward. Now, having said that, what I will also say is that if you were not willing to do that at the point that that came up, ma'am, then now what you have is you have the incurring of costs in this case. And the incurring of costs becomes an issue because when attorneys are hired, and they file written documents and what have you, the incurring costs on behalf of the client. And so they have to give an account for that. And that's kind of what I suspect is a part of this. So here's just my thought about it. I can't get into that level of negotiation, but you raised an important issue. That important issue is that you suggest now that you're willing to call it even, drop it, and go on about your business. They go on about their business. And that there was a discussion along those lines at some point previous in this case.
Sure.
That probably means that the parties need to talk about what the cost is of resolving this case, rather than some dollar amount based upon the underlying claim. But again, let me. Well, I tell you, I'm trying to help you all find a way. I don't know if you'll get there, but in light of that discussion, I'm sending you back while I work with this last case. Go back, counsel. Let's see, talk about this.
Okay. Thank you, Your Honor.
All right, thank you. All right. They got a little tricky on me there. My goodness. All right, we're back on Teal versus Moles. That's the suffix 2808. All right. So like I said, I don't have the complete file. Thank you, counsel, for your patience. Thank you, Pam, for your patience in this regard. Again, this seems to be something about an automobile, and it seems to be that this is a claim for $3,500.
Yeah, just some interference. I'm sorry to interrupt.
Where's that coming from?
Everybody's on two
I
devices.
couldn't, excuse me, I couldn't really hear you. For some reason, the phone was loud, but then it got real low. So
Okay.
I had went on the Zoom with the on the phone. I apologize.
All right, man. No, not a problem. So you're asking for $3,500. What are you asking for $3,500 for, man?
Okay. First of all, when I took the car to him, I told him, he told me that he could do it. I asked him to do one other part, but he said that he would have to take the motor. So he charged me $2,900. But
I
now,
got you, sir, talking, then I said, let me stop you. That's my fault. Let me stop you for a moment. Okay. You took the car to Moles Advanced Tech to get a certain repair. That's what you're saying to me, correct?
yeah.
What was it?
And the reason why I'm charged is because
what were they supposed to repair? What part of the car were they supposed to repair?
he was supposed to change the time chain guide, but then he said that if he did, he'd take the whole motor part. So it would be best to just do another motor. So he took the other motor out, my car, which the only problem he had was that ticking noise, and I can stand him on my cars. So he changed the motor. And when he changed the motor, I asked him, are you sure you're gonna give me a motor? Because it's like one of my favorite cars. He said yes. So changed the motor. But from my understanding, when you take a motor out, the good parts you take off of the motor that you are taking it out from. I wind up spending more money on other parts that I know that I just replaced and they were brand new. That's why I charged $500 plus the time that I was down and I couldn't get work.
Okay, so did the motor, when the motor was installed, does the motor work that was installed?
No, no. I went right back to him and I told him, I said, the motor was smoking. It had bad fumes. My sister passed away and I got her fired. So at the time they were young. They couldn't get in the car. We couldn't go nowhere. I took it right back to him and told him the car was messed up. He said, but I got other cars, so I had to wait. And I'm like, why do I have to wait? And I just gave you my money. Like, I need a vehicle because I have to get the kids back and forth to school. He may make for like a week or two, maybe, to even get it back in there. And then when he got it back in there, he kept for a month, told me that the motor was blown. Also, he took my catalytic converter off my car. He didn't tell me. But so in the process of me waiting to take it back to the shop, I took it to a muffler shop on 8 Mile and Hayes. They put the car up there. They said, ma'am, you don't have a catalytic converter. He ran straight by, sent pictures of all the welding stuff he did to it. I went and took it back to him. He said, yeah, he removed the catalytic converter. Now, from my understanding, when you remove them, you don't need to check the exhaust. But he took my catalytic converter. He tried to put the exhaust on my car. I don't need no exhaust. He put some on it. About we gonna say, no, not gonna work.
Okay, so what's the end of the story? You get your car back? What happened? Did you get it repaired?
When we got to the end, he said, the motor is gone. You can buy another motor, and I'll charge you $500. Put it in. I said, I'm not gonna do that. I paid you for a motor. That's all I had.
All right.
I'm not gonna rebuy more again and then you. Yes, I did.
How much?
Yes, it took me a minute, but I wound up getting repaired at another shop, and they put another motor in.
How much?
That motor was $2,200 or $1,800 because it gave me a discount.
All right, gotcha.
Yeah.
All right. I just wanted to get kind of a synopsis of what the plan was here. It seems that it was a set of varying circumstances along the way. Kevin, your client's position regarding this matter, I'm kind of trying to see if there's any room to kind of talk about this and maybe try to get it resolved.
Well, Your Honor, I believe that it's a warranty claim. According to my client, he indicated that the vehicle was not returned within the 30-day warranty period upon the engine. I haven't actually received any documents from the, including with discovery that I did send with regard to payments for any type of replacement.
All right. So it seems that, yeah, that it needs a little bit more opportunity maybe to litigate this. Ma'am, did you receive some documents requesting some information from you, requesting copies of any payments that you might have made? Did you receive anything from in this case?
Yeah. Yes, I did. Prior to you becoming my judge, I had a judge for him. I believe it was Judge Johnson. I had already emailed him all that the email him, so he has all the pictures. He has all the documents.
Your Honor,
I did about 50 times.
If I may, this is the second time that the plaintiff has filed this case. The first time was dismissed without prejudice. And both times they were then removed from the from the small claims division to the general civil division. I do have to say there seems to be a little bit of a broken process when filing a removal about entering the attorney as the attorney of record and then, never sending the notices properly and otherwise. Either way, we are on track because I just go to the register of actions and send multiple times appearances. So I finally get in there. But I believe this is a factual issue of whether or not it in fact was returned for within the warranty period. And then also, of course, if there's anything other than the plaintiff's statement with regard to that the engine itself was replaced or there were repair work or otherwise with regard to the damages. I did send discovery and that document wasn't then provided. If she does have it, I would ask them to please provide it. Otherwise, I would object when we come to a trial.
All right, so what I'm going to do is, I've already sent a new date on this matter. What was that date again, Madam?
12/20, Gary.
Yeah, 12/20. And so, Mr. Murdoch, I do see your name finally on the notifications. So you would have received that 12/20.
Yes, we just received it yesterday.
You received the 12/20 date as well, Madam Council, ma'am.
Yes, Your Honor. And excuse me, Your Honor. I sent you documents, so, and the same document sent you, I sent him the repairs, from, God, what is their name called? The repairs that, for the motor, that documentation, that seat is in your file. This was here.
Let me stop you on that. Here's what I'm going to do. I'm going to set it for December the 20th. And what I'm going to order is that Ms. Hill present to the attorney, his address is on that notice that you received on the 20th for the 20th of December. So send any documents that you have regarding your claim to Mr. Murdoch. That is any money that you paid, evidence of money that you paid, any receipts for repairs that were made either with Mo Advance or any other shop that you might have spent money on this vehicle. Send that information to Mr. Scott, Mr. Murdoch, I'm sorry, at the address that's on the notice that you received on the notice of hearing. I know that you sent some documents before, Ms. Teal, because this case was filed a couple of times and it was before a magistrate. Now it's finally in the right place in front of a judge. I'm the judge that will be on this case. And so what I want to do is make sure that everybody get to exchange whatever information they have so that we can take a look at what this case is all about and try to get it resolved. If not resolved, short of trial, then I'll conduct the trial hearing and make a decision as to what the facts are, then determine the outcome of the case. So as soon as you can, send those documents on to Mr. Murdoch. And Mr. Murdoch, any items that may be requested by Ms. Steele, if there are any documents that you want that might be in the hands of Mo's Advanced Tech, then you're certainly entitled to copies of any documents that they may have regarding this. And I'm going to go ahead and order that Mo's turn over any documents regarding their dealings with Ms. Steele regarding the purchase and the repair of the automobile that is the subject of this dispute. And ma'am, you got to do the same thing. Any documents that you have that show
No problem, Your Honor.
any agency you took the vehicle to, turn those documents over to Mr. Murdoch. And so the parties should mutually do that within the next 21 days. Turn over any documents mutually. And then I'm opening discovery through the 20th. So that means that if you want to request anything else, request to admit anything along those lines from the other party, you have through the 20th of December to do so. I will treat that 20th of December date as a final pretrial conference date. You'll receive an order scheduling this matter from the next few days in the mail, right? I do wish both sides well. I know this is a lot involved here, but it looks like now it's finally on track. Mr. Murdoch, unfortunately, and I'm presiding over this division now, the civil division, as of a couple of weeks ago. I'm going to try to get that piece straightened out because this is the second time this week that it's come up that when cases are removed, the removal is being processed, but somehow there's some slippage where the attorney that should be added in or the party removing is not being added in. So it gets removed, but they don't know anything about it because they don't get any notices. And this is, I identified this problem a couple of days ago, so I'm glad that you drill down on this. And so we're going to make sure that more attention is being paid to that across the system here at 36.
Yes, thank you, Your Honor. It's I was able to find by having the register of actions being online now is is considerably more helpful. There are just two things. The first one would be just to say probably to Ms. Till, anything she intends to introduce at trial to get me a copy of it. Okay. And then for Ms. Till, it was the only, I have photos of the, it appears to be exhaust system. I have a Better Business Bureau letter that was written, and I have from an exhaust shop replacement for ball joints. And that's the only documents that I have.
You know, I bring documents to your office, so I'll make sure I bring all the documents to your office within 20 days. Also, I just dropped off at the 36th district first interrogation. That be long word.
It's hard to hear.
Paperwork.
It's hard to hear you now. I don't know if you got away from your device because your sound is really muzzled. So get closer to your guys.
Okay, I said I just dropped the first interrogate that long word. I can't pronounce it, but I've dropped it off, and it should be on clerk's desk, so that file should be there as well.
Providing the answers to interrogatories, Your Honor, that I had sent to her.
Yeah.
The notice that I had on this case was that today was going to be a trial date. And so I sent the answer and I sent discovery out right away. So I believe that she's left a copy of her answers to the interrogatories with the court, which aren't absolutely necessary, but I would let you instruct the plaintiff on the court rules.
All right, but she's turned a copy over to you. Is that correct, counsel?
Yes, that is correct. It's just I don't have any other documents other than some photos, nothing about the actual replacement cost that she's requesting in her damages.
Right. And so anything, that's a good way of putting it, anything that you're going to introduce to me at trial, your evidence and what have you. Make sure that you get a copy of that to Mr. Murdoch's office within the next 21 days. And the items that he's
I will do, Your Honor.
he had under his control.
No problem.
He's going to submit those documents to you. All right. All right. So you'll get an order from me in the next few days, and your final pretrial conference date is going to be on the 20th of December, and you already have the notice that's at 9:30 a.m.
Okay. Thank you, Your Honor.
All right, good day to the two of you. All right, all the best.
Thank you. Bye-bye.
Somehow, Mr. J and Ms. Durham, I managed to make your case the very last case today. Somehow you made it. You made it to the. Welcome back, Ms. Durham. Welcome back, Council. I somehow managed to make you all last. Didn't start out last, but last.
That's okay, Your Honor. I appreciate the ability to converse, and actually Ms. Duran left the breakout room. I needed to contact my client to verify what I could do, and I actually haven't said this to Ms. Duran, but
let me send you back to do that. Okay.
No, it's okay. We're good. I guess when I explain it, maybe you'll understand that she'll be okay. But it's what she essentially wanted, which, at this point, Your Honor, and I don't know if the court would want me to prepare the order, if the court would do it or whatever. If both parties, Ms. Duran would dismiss her original suit with prejudice. My client would dismiss their counterclaim with prejudice. Everyone walks away, essentially, is the deal that Ms. Duran brought up that my client accepted.
All right. Well, Ms. Durham, that made sense to you?
Yes, sir.
Well, you may need to consider going to law school. You brought your way to the end here.
I want to be a lawyer.
Well, the system works in some ways. Sometimes it can get to be really, really strange in a number of different ways, but it works, and somehow this has worked out. So council is gonna send an order to me. It's gonna mutually dismiss this case. You're gonna withdraw your claims, in case be dismissed. They're withdrawing their claim, the case is dismissed, and everybody goes on about their life. And, it's a learning experience. That makes sense to you?
Yes, sir.
And so, Your Honor, I won't do it as a stipulated order that both parties sign, but I'll do it under the 7-day order, if that makes sense. 7-day rule.
Yeah, or you could send that order today. Here's what, just send it by way of email. And the order is mutually dismissing the matter. And then you don't have a problem if he signs off on the document for you by consent. And the consent is simply that you agree to dismiss your claim in exchange for them dismissing their claim with prejudice. That makes sense to you?
Yes, sir.
You're gonna get a copy of it, but when you get a copy of it, it'll already have my signature on it. We'll have your signature on it too, but it will just by consent be that you allow
Okay.
to consent to it. And the only thing that it's doing is saying that you dismiss your claim, they dismiss their.
Yes, sir.
And that's not me, Your Honor. So I'll submit a stipulated order to your email. Is it the Latifah Hunter email that you gave earlier? I wrote that down just in case I needed it. So
Yes, sir.
I've got it.
I'll sign it up and Mr. Durham, you'll get a copy of the finished document.
Perfect.
Okay, thank you, Your Honor, for your time.
All right, no, not a problem, not a problem. Like the board counsel.
Thank you, Your Honor.
Thank you, counsel, for your patience as well.
Absolutely.
All right, good day.
Have a good day, sir.
This person, Sherman Sharp, they should be in Jones Court. They're in the wrong court.
All right, Mr. Sharp,
Yes, Your Honor.
how are you?
Outstanding. How are you, Judge?
In the wrong courtroom.
You're in the wrong courtroom, but they're telling me that, shouting out to me that you're in the wrong courtroom.
Jones Coleman.
You're supposed to be in Jones Coleman.
In,
Alicia Jones Coleman is where
That
you're
was at
supposed to be.
8:30.
So, do we have the,
Yeah, he just had to put in 360-436-0000.
so 436 is the courtroom you want to be in, so 360-436-0000.
They probably not on there no more. He probably got called a clerk now. This clerk's number is,
And Mr. Sharp, let me give you the clerk's phone number as well, so, because she may not get on Zoom anymore.
Okay.
So call the clerk and just let them know that you were in my courtroom. That phone number is
965-2404.
965-2404.
965-2404.
Yes.
Okay, very well. Thank you, Judge.
All right, sir. Good day to you.
Nice talking with you.
Yes, sir.
Bye-bye.
Tifa,
Mm-hmm.
can I get the spelling of Monique? Is it Monique Teal?
Yes, TILL